Welcome to Sullivan and Cromwell Sidebar, where we talk with our different partners about some of the most interesting issues they've seen and what they are seeing on the horizon. I'm Jay Clayton, and today we are joined by Mario Schollmeyer, who is a partner in the firm's capital markets group. Mario advises U.S. and non-U.S. clients on a variety of public and private capital markets transactions. He also regularly advises clients on ongoing public company matters, including disclosure and corporate governance issues, as well as SEC regulatory matters. Mario, you have a great practice. Welcome to S&C Sidebar.
Thanks for having me, Jay.
You've been in New York with us since 2014, and you've been a partner since 2023. In that time, what are one or two of the most interesting issues or topics you faced?
I handle IPOs, I handle secondary offerings, debt and liability management transactions. I also advise on complex public M&A transactions. And across those areas, I think one aspect of my work that I would highlight is really multi-jurisdictional deals, whether you have a cross-border capital raise or a cross-border M&A transaction. In those transactions, the interaction between U.S. securities laws and international securities laws is critical, and so is the interaction with U.S. and international regulators.
Yeah, let's face it, law still remains very jurisdiction specific. While markets are in many ways global, at least investors are global, capital flows globally. Maybe it gets traded and raised in the U.S., but operations happen all over the globe. How do you deal with that fact? The fact that we're U.S. lawyers largely, but other laws apply. Many of your clients are non-U.S. people who are dealing with U.S. law for the first time. What do you do to deal with all those overlaps and inconsistencies?
Well, I think it is very important, and I think that's one of our strengths at Sullivan Cromwell, that we stay coordinated across offices. And I work regularly with the offices in Europe and other jurisdictions, and I also work with law firms, for example, in Canada. I advise on local law matters for transactions that have a Canadian law overlay. So I think it's very important to stay coordinated in that respect, and I think that's something that we do very well.
Yeah, it's easy to find conflict in law. It's more of a challenge to find consistency, and I think one of the things that I know you do well and we do well here is finding those consistencies. How do you bring that generalist approach to bear in your practice?
Sullivan Cromwell is a firm that historically has been a capital markets firm, and I think we have maintained that very broad focus. So we really train our capital markets lawyers to be securities lawyers. So they are trained to advise on a broad range of securities law aspects, and that means we are not focused on specific submarkets or segments, for example, debt capital markets or equity capital markets or transactional advice or public company disclosure advice. We are really securities lawyers. And I think this is relevant in two ways. And I think the first of the two is that we stay in the flow, even if there is a downturn in the market, for example, the equity capital markets. There is almost always an uptick in a different area where we practice, for example, distressed transactional work. And we've been consistent in the past in maintaining flow during those periods. For example, during the financial crisis in 2008, during the bank liquidity crisis in early 2023, and also during the pandemic.
An investment professional might say it's analogous to a risk parity trade, but I agree with you. And I think it's not just debt or equity or distressed versus venture. It's also developments over time. The importance of the capital markets to financing has only increased during the course of our careers. Almost in the U.S. now, 70% of capital is raised in the capital markets away from the traditional banking markets. So let me shift gears. How do you take these complex issues of cross-border transactions, different laws and developments in markets, and get your clients comfortable? What are your techniques for engaging with your clients?
Well, I think, again, my approach has been to build relationships with clients, not only in the transactional context, but also in the public company advisory context. So we advise on transactions, but also on corporate governance and disclosure matters at the same time. And so you develop relationships with the client that allow you to have a deep understanding of the client's business, but also of the people at the client.
Mm-hmm.
And that really facilitates work in every aspect. You know what they expect and you know what you need to provide in terms of structuring a transaction.
Yeah, I find that I always learn something from our clients. What's your advice to younger partners, associates at Sullivan and Cromwell on how to develop those kind of good relationships with clients?
Well, as a firm, we have a very selective associate recruiting process. And of course, we hire the best law school graduates. So generally, the idea is that associates that start at Sullivan Cromwell have the potential to become really great lawyers. And one aspect to that, of course, is that you can work with the client and that you enjoy your work with the client, that you enjoy understanding the client's business. And in addition to that, that you are interested in the legal issues that the client's business present and solving those issues together with the client.
I think that's right. I often say that a common interest with your client around the law or around the client's business or around something else is a great way to build a relationship. So you've been in New York practicing securities law for over a decade.
Yeah.
What's the most significant change that you've seen over the course of your practice?
There were so many. How the regulatory landscape has developed during that time has been really impressive and significant in many ways. I think what is something that I think will be very relevant in the future is the SEC's approach with respect to digital assets, which is also relevant for my practice in many ways. And the SEC since 2020 has regulated by enforcement, as you know, in that area. And there is a different approach at the horizon under the new SEC, at least based on recent statements. And I think it could be really interesting from a capital markets perspective to see that area, that industry evolve so that a disclosure regime can be established, that capital market transactions can be facilitated, capital formation can be facilitated in that area.
So my view on distributed ledger technology and its application to the financial markets is it's inevitable. My real question is, when do regulators start treating it as a technology instead of as a product? I don't know if you feel that way, but
it's a challenge and there have been many approaches. And I think it will be very interesting to see how the new SEC is going to balance those two different characterizations, whether you have a product or a technology, or whether you have a security or a commodity. Those are really interesting and complex questions. And to find the right disclosure regime, similar to Regulation AB, for example, for asset-backed issuers, it will take time, but it will be presumably an open process.
I think that's a key point you made, that many of these products that are enabled by distributed ledger technology cross over the securities markets into banking markets, into payments markets, and into areas that are not regulated except by state law. Thank you for joining S&C Sidebar.
Yeah, thanks for having me.